today. We're going to start with House Bill 620, and we're going to recognize our Vice Chairman to bring this one up. Essentially, I think we're doing a strike all of the Senate language that we had passed already that he had gone in depth with. But there are a few minor changes that the Commissioner has asked for. So this is his bill. We will certainly recognize our Vice Chairman.
Thank you, Mr. Chairman. Fellow committee members, what we have here first is a strike all that puts our language into the bill that we've already passed and that I gave a good lengthy explanation of in here and on the floor. So with that being the case, I'm going to make a motion that we adopt that strike all, but before doing so, I'm going to let you know we are going to have a couple of amendments once we adopt the strike all, and I will be explaining those amendments. So my motion is to adopt the strike all. Thank you, Mr. Chairman. So we've got two amendments here. Then these have come at the request of our Honorable Commissioner of the Department of Public Safety. So I will go over those briefly. The first, I'm flipping through our page numbers here, so bear with me. The first amendment is going to be found on line 3, and I'm sorry, turn to the strike all, please. You'll see the first part of your packet is the House bill. If you'll turn over to the strike all, it's page 15 of the strike all, lines 383 through 387, and not the full line 383, just the word "the" on 383. That will be, we're taking that out. There's been just through negotiations with the personnel board, this is not felt to be needed any longer, so we're going to take that out of this was in our original bill. We're going to take that out now. With this amendment. So at this time, I'll make a motion that we amend by striking the underlined portions found on lines 383 through 387. I'm happy to entertain any questions on that amendment. Have you heard the amendment? Any questions on that amendment? All in favor, say aye. Aye. Nay. Okay, thank you. And our second amendment, I'm going to ask you to flip back to your original, the original House bill, because what we are going to do is going to accept one of the sections out of the House bill at section 9. And if you'll give me a second, I'll give you that page number of the original bill. Okay, section 9 is found on page 25 of the original bill. It's going to be lines 629 through 690. And what the amendment does is it adds that section 9 into our strike all. And that section creates provision whereby the Mississippi Bureau of Investigation will investigate office-involved shootings. Unless it's a MBI officer involved in the shooting, then there will be another agency appointed. It also allows the Attorney General's office to be the office exclusively responsible for presenting officer-involved shootings. So that is the amendment, is to move that section 9 into our strike all, which would therefore make our section 9 and strike all section 10. And I'm happy to entertain any questions on that amendment. Any questions on that provision? Yeah, make the motion to amend as described previously. Adopt the amendment. All in favor, say aye. Aye. Nay. Guys have it. Okay, and that is the last amendment that I have. So now my motion is title sufficient, do pass committee sub as amended. As amended, strike all. First, let's hear from our commissioner. Mr. Tyndall, this is your bill, so we want to make sure we're doing it the way you want it. Telling us what's going on with it.
Thank you. I appreciate it. I appreciate you urging it to go past. last part of it, last year, y'all passed the task of investigating all the things that were now with the eyes, it's all separate division. Things and other things. They're not investigating. That's it. Red house. Also, prosecuting. The DA, some DAs, the DAs, the DAs, I think prosecutors association stands on inside out. All respected and be good. Try to demonstrate a setting by standard on how we investigate all your law shootings across the state. Like it would be good to be prosecutors across the state. Standards and media and everything, there across the state.
Questions for the commissioner? Thank you for being here. Thanks, Commissioner. Yes, sir.
So the language has been worked on here, but writing with this just like this. So I do any of the things that we did, we will leave discretion up to the judge to ensure that the congregation is all protected. We just basically gave them a prosecutor or straight to the judge and then the judge can decide. Second question is this allowed for audio testimony lines got to be will speaks to the testimony itself has to be done allows the jury to see and I always thought better to confrontation forms than to have in-person testimony.
Mr. Degree, would you like to speak to Senator
You're already
Barnes?
able to language. explain. Advanced services, deciding whether or not it's the language says use audio visual.
People online can't hear your questions, so you might want to. Kelly, could you shut that door?
The language of the bill says audio visual communications. Does that mean audio like with no picture, or is that like a Zoom where you can see them? Or is that clear enough?
That's the language. Great questions. Any others? All around, you've heard the motion titles for the should do guys as amended. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Thank you, Commissioner. Thank you. All right, House Bill 679. This is Mississippi Bill Press Act 2022. Of course, we already had one that our own Senator Sparks had handled and authored, and I believe the strike all puts his language into that, but we'll recognize Senator Sparks if he will just refresh us and explain what we're doing here.
Certainly, thank you, Mr. Chairman. This bill is to address the problem we're having, particularly with fentanyl that is being added to or pressed into pills that resemble a pharmaceutical drug. No one really should have the pill press encapsulating machines, things of that nature, unless they are registered with the Board of Pharmacy as a pharmaceutical producer or the DEA or some other lawful authority. And what we're asking is that you simply register these with MBN so that if you sell that or transfer that, that we know kind of what we're dealing with. The second thing is it does not make it a penalty to fail to register. The penalty is if you are possessing this with the intent to manufacture. So, there was some arguments made. If I had my grandfather's pill press back when he was a pharmacist, that's not what this does. This is attacking a problem we have across the state, across this country, with unknown ingestion of fentanyl because people are taking pill presses and making it look like a safe pharmaceutical. This is a bill that we worked with Department of Public Safety and MBN, and we did strike all of it and put the language that we had worked out with law enforcement. I'll give any questions, Mr. Chairman.
All right, you've heard the explanation of the strike all. Any questions for Senator Sparks? Not Senator Sparks for a motion.
Motion, title sufficient due pass, committee sub. Strike off.
Strike all in favor say aye.
Aye.
Any opposed, nay? The ayes have it. All right, we're going to skip around a bit, go down to House Bill 907. This was a doubly referred bill to us by our friends over in the Corrections Committee, Ms. Salter Barnett. Would you like to tell us what y'all did in Corrections?
Thank you, Mr. Chairman. We didn't do anything to the bill, Chip. This was similar to the one that we passed out that you authored in the Senate. And so we just agreed to do this to keep both of these vehicles alive.
Yeah, so what you did was to, correct me if I'm wrong, I believe in corrections, y'all did a strike all putting the Senate language into the
Exactly.
reentry court bill, which was very similar to what they had. I think the two versions were quite similar anyway, but just to make sure we had vetted the language, I think you all in corrections put the Senate language into the reentry court act so that what we explained in committee on the floor is still.
Exactly. This would be exactly to what Judge Hale wanted and with taking all the other stuff out of it.
Exactly. So this is basically applying the sort of idea of drug courts for drug crimes to other non-drug related offenses, accepting out the violent offenses.
Exactly.
Questions for Senator Jeremy Barnett on this strike all?
So I think I clarified this before. We're basically adding any of the crime other than that 9732. Is correct?
That's correct.
So any of that list, grand larceny, embezzlement, money laundering, any of that stuff, they can go through a reentry court instead of being, it's basically like, almost like a retrial diversion.
It really is. It's, and of course, it's up to.
Y'all gonna give me my law degree osmosis.
You need one. You out those violent offenses. It gives the senior circuit judge in each of the districts that want to do this, it doesn't mandate that they have to do this. It gives the senior circuit judge in each of our circuit districts around the state the ability to impose these new rules if they want. And within those rules, there are lots of criteria you have to, check the victim, check the community, check the
And my other
DAs
thing
and all that.
is, this could be a quote common nucleus felony. Correct? So this could be what's designated a common nucleus felony, so it could be a cluster of felonies that's happened in one crime spree, and they can get their record wiped clean if the judge decides that they're a candidate for this.
Those crimes aren't violent.
But that's what I'm talking about, just
Exactly.
a cluster of long offenses,
That's
not
right.
violent, then the judge could put them in a reentry program for even a big crime spree.
Up to 3 years.
I just don't think I can do that, but, that's what y'all want to do.
Super smart.
Thank you, Mr. Chairman. In response to Senator Hill's question, I just want to make sure, and this bill will go to conference, most likely, because it has reverse repealer in it as well.
That's correct.
This, as I understand the bill is written, this would be for people who are going to actually be incarcerated. That's the reentry portion of it. And I think sometimes when we say this is like intervention court, it's like drug court, what we mean is when you come out, you're in that regular supervision. Someone who is in reentry court will have spent potentially up to 3 years in the custody of MDOC for nonviolent offenses, which is a pretty unique situation because they cannot get parole or good time credits while they're in this. That's an agreement they enter into to have at the end of it potentially the opportunity to have it expunged. So I do just want to be very clear. This is a lock them up on a day for day for non-day for day crimes because maybe they do have a nucleus of crime. So I do think the intent is to do two things. One, it is when people have just crossed a line repeatedly, that this is a way to not lock you up, throw the key away, but to say, we're gonna let you be incarcerated. We're gonna try to give you support, help, job skills, training, etc. And when you are released, then you have to go into the reentry court and perform, or you go back to prison. And that's that. I just want to make sure that it's not akin to intervention court because it's very different.
So this would have to be decided at sentencing.
That's correct. Yes.
That's
So if it's gonna be day for day, they're gonna have to decide if this person's a candidate at sentencing, not after they've been in there for years. They're gonna have to decide at sentencing if this person's a candidate, correct?
That,
Because most of them aren't getting day for day.
well, I understand, but I'm just saying, as you look at the bill, to enter into this agreement,
I
you
understand
forego.
that, but what I'm saying is, in order for what you're saying to happen, that it's day for day, they're gonna have to, the judge is gonna have to decide, and the inmate's gonna have to decide at sentencing.
That's correct.
If this is part of their
That's correct.
plan.
In other words, if you're standing before the judge, your defense attorney, you, the defendant, the judge, the DA, are all going to have a chance to weigh in on this. And if that is the sentence, I'm sure the judge is going to articulate very clearly the agreement you're entering into means, sir or madam, that you will not receive meritorious earned time. You will not receive good time, trustee time. You are going to go complete this program. Then you're going to come back before me, the judge, and I will determine if you've qualified to even get out. And if you get out, then you go into reentry court. I just wanted to.
And further, you also have to enter a guilty plea.
That's correct. That's right.
Yeah, you waive your defense, you enter a guilty plea. You're actually sentenced for,
Right.
up to the 20 years, because anything over 20 years, you're excluded from under the bill. That you receive your sentence, and then if you enter into this agreement, you go in up to 3 years into the jailhouse, where you spend the night, you do your work programs or whatever during the daytime, potentially outside of the jailhouse. Or in the jailhouse.
Is there a minimum time that they have to spend? I haven't read every detail.
I believe the language is up to 3 years, so I don't
3 years.
know that there's a minimum.
So
per se.
pretty much any list of those crimes that's outside of 9732, you can do those crimes in a minimum of 3 years, day for day, and get in this program.
But-
If you qualify and the judge says you.
But also, Senator Hill, what you have to understand is that if they do the 3 years, if they had a sentence of 10 years, And if they decide to go through this program and they default on it, they go back and do all the time. So it's not like you just, I'm just gonna go to jail for 3 years and get out. So that's,
I agree, and honestly, whether they in this program or not, if they've done their time and they're out on probation, they ought to go back anyway if they violate it. That's just my opinion.
Alright. Thank you for the good discussion. Any other questions? Senator Barton?
Thank you, Mr. Chairman. I was just thinking, that's a great bill. I think you done a good job, Senator Barnett. Is this retroactive? So, to people already convicted, are we gonna see some
No, this
PCR
is-
hearings or anything like that?
this is not retroactive. Yeah, last year, you know, we tried to pass the same bill. And when they got to the House, because of some other things that was added in the point of order, so it ended up dying. So same thing happened now. That's why we took the Senate language that was done exactly what was asked for. It's in two bills, a Senate bill and now it's been the House bill to do exactly what was asked for. So no, there's no retroactivity.
I just know we pass new programs like this, which are good programs. I get letters from inmates and so forth. Hey, does this apply to me or not? So do a PCR hearing, whatever. So I was just curious. Thank you, Mr. Chairman.
Thank you.
Any other questions, comments? All right, Senator Sparks, or actually Senator Barnett, I'm sorry, for a motion.
Title sufficient to pass as amended, strike out.
For the motion, all in favor say aye. Aye. Any opposed, nay? Yes. All right. Going down to House Bill number 400. This one deals with riding bailiffs, which honestly I had to try to figure out what a riding bailiff was, but these are the law enforcement persons inside the courtroom that are referred to as, I just call them bailiffs, but apparently they used to ride with the circuit judge around the district, and so they were riding circuit judge bailiffs. So this is what the bill does. I think Mr. Sage is here. He represents our bailiffs association. Okay. For the bill. Sorry. Tell us about your bill. Gotcha.
Statute that covers all their different types of compensation. They serve for bail and justice. They are paid under this statute. So explain the right way. The chair was correct, but sometimes there's still some people private individuals, by the county, they're paid by the county. Sometimes it's sort of deputies do it. That's part of it, figured into the sheriff's. This is, that's this, is increases compensation, it's been $55, you know. So even the people that are doing this is the private individuals, you see some guys that don't hire, they make more. This is some problem. But like I said, this is my specific issues, you know, as well as involved. Be glad to hear you.
Okay, so on the strike all, you were explaining just the bills that came to us from the House. There is a strike all that we have, and I'll explain the difference and the reason for the difference. So, but I believe the House bill just moves it all from the current amount of $55 to $100. There were some concerns that depending on the county, because this is after all county money, these aren't state dollars that pay these folks. These are county dollars and the counties that pay these individuals. And if a particular county is in a financial crunch, we didn't want to just make a blanket raise from 55 to 100. So what the strike all does, and you see it in a loose sheet handed out with your attachment there, is it says between 55 and $100, and that would be determined by warrant of the board. So the judge will decide, and most of them probably will just go ahead and make it $100. But if there happened to be a financial crisis in that particular county, that particular time, the judge could adjust it somewhere lower than 100, but more than 55. So that's the difference for you in the strike all bill, as I understand it. And that was just a concern because some counties may not have as many resources as other counties do at any given time. So that is the strike all. Senator Hill.
Probably why they didn't come by.
Oh, that, that's true.
But I appreciate your strike off.
Okay. All right, any questions about the bill? If so, we'll get Mr. Sage to answer the questions about the bill itself, but if you have any questions about the strike all, me or Senator Hill will try to answer those questions. All right, any questions at all? If not, Senator Hill for the motion.
House Bishop do pass, strike.
All right, you've heard the motion. All in favor, say aye. Aye. Any opposed, nay? The ayes have it. Thank you, Senator Hill. Thank you, Mr. Sage. I think House Bill 604 has been added also as a, that's been added out on there. You have a loose form in your packet. There is both a House bill and a proposed strike all, and I think Senator Sparks maybe has been working some on this one. I believe this is the one dealing with the 120 days. The 120 days for the suspension of the driver's license.
Yes,
So if you'll talk to the original bill maybe, and then I'll get Ethan to tell us what changes we made in the strike.
certainly. As I understand, and we passed this bill last year, there are two suspensions that go into place when you potentially, when you are charged with driving under the influence charge. The first of which is the refusal suspension, and that is a 90-day suspension. The second suspension is a 120-day suspension upon conviction or non-adjudication. We're not shortening that suspension. We're not eliminating that suspension. We're just allowing the judge to state when that suspension shall begin, because what we're having in actual court situations is you go to court with your client, the judge renders a verdict, and potentially 75 days, 90 days later, a letter comes from the Department of Public Safety, Driver Services, and says that in some date in the future, maybe another 30 or 60 days out, your suspension will begin. So we have people in limbo. We want them to pay the punishment, which is 120 days. We just want the judge to be able to assign when that date will begin. And that is the intent of the bill.
And I'll tell you what the strike all does, like you said, or what council is here, I remember, is there were some other, I think, code sections in the bill that weren't changed, but dealing with interlock and whatnot. And we love our house friends, and sometimes they will implant little code sections to then fool with later in conference. And the purpose of the bill really is to define what the 150 days are, when it starts and when it ends. You know, I'm good with that. I think that makes a lot of sense. I'm not okay with including some extraneous code sections that aren't needed for that, that could then be labeled later on in conference. So the strike all does everything you said and then strikes all the other code sections out that were not needed for that.
If I may, Michelle, the only, and I'm the only concern I would have if they brought that forward as it relates to interlock is in lieu of suspension, you can put the interlock device in your car for 120 days, as long as we can still capture that when the judge says the suspension begins for the interlock. I guess that may be the only reason, but I'm certainly not defending the addition of numerous untouched code sections. But I just want to make sure if that's part of it. We do have a
I
version.
agree, and we can bring that back in conference, and they may try to, but I just want to send a message that they're not interested in eliminating another code section.
Thank you, Mr. Chairman.
Senator Stevens.
Thank you, Mr. Chairman. The only concern that I have, I agree with Senator Sparks, we've discussed this last 2-3 years.
Y'all's area in practice, so y'all tell us what's going on.
So my only concern is just, city courts at night, the judge signs an order, clerk sends it in to the Department of Public Safety, say for 10 days. You're wanting this to be retroactive, the judge signed the order, or I just feel like there's a delay. There's gonna be, the Department of Public Safety might not get a letter out for another 2-3 weeks. So we're looking at, 30 days for that, they still get a letter, or serve quarter of the time. So I don't know, I'm just worried about the delay.
I thought that's what we were trying to address, that there was some confusion.
Well, now the problem is, like Senator Sparks is saying, I mean, it could be 6 months, they get a letter saying your license was suspended, or they're gonna be suspended, no one knows when the suspension's gonna occur.
Would this be helpful?
I think this is very helpful. I'm just concerned that saying the first day the judge signs the order, when the Department of Public Safety is not gonna know. It's at least 30 days.
in speaking to that, and I think, again, as reverse appealer, we're expecting to deal with in conference. I agree with Senator Suber. I would not choose language on the day when the judge signs an order. I would choose language that says on the day in which the judge orders. You know, because the judge knows that if I'm in municipal court in some town at 6 p.m. and I sign an order today, you have 5 days, the clerk has 5 days to send that to DPS. So I think that's part of the concern is that it would confuse that. I believe we can clear the language. What we're wanting to do is let the judge's orders be well received when they get to DPS.
Yeah, so I just got a question. So I'm guessing that the practice now is whenever DPS gets the order and sends out the letter, that's when the 120 days start. So we're saying at the moment that the judge makes this order, our 120 days. I'm trying to figure out what are we changing? What's the practice in this?
Again, the practice at this point is whenever the abstract of conviction goes to the Department of Public Safety, whenever it is eventually looked at, which could be a period of time, that then a letter is generated, and that letter goes out at some time in the future, and I've seen it as long as 75 days to 90 days. Then there's a date in the future your suspension begins, and I'm assuming at one point DPS was trying to give you notice of your suspension and give you a few days to get your affairs in order. The problem is it is causing people to be suspended for almost 6 months or more because the notices are not going out. The end result of this bill, I hope, is that when a judge signs an order and says you shall install interlock or your suspension shall begin on this date, that governs when the suspension begins to run.
I totally get that. And I guess I have one question. Forgive my novelty on DUIs. I've only done a few of them. But it's been my understanding that when someone is charged with a DUI, a lot of time, like the law enforcement will take their driver's license at that point. They're really not. Does that help with that thing? Because I mean, you may not have trial for 3 or 4 months.
That's a separate issue. That piece of plastic does not mean you're ineligible to drive because they give you a receipt from the toxicologizer machine, and that receipt is your permit to drive for the next 30 days if you submitted the test, 45 days if you didn't, and then there's a procedure you can ask for an extension of the driver's license if you did not refuse the toxicologizer test. So it will not stop that. I understand that that's concerning, but it's not well explained, but technically you're given a receipt for your driver's license when you get a DUI, which is your permit to drive.
Yeah, absolutely. And that's exactly what I tell my people. Sometimes people don't come get a lawyer and then they just not driving this whole time. They think they're done. But my final question regarding this is so if it doesn't help with that, but it does help. I guess ultimately it's good because it helps to curtail and bring down this period of time when people aren't driving and think they should be driving because of all of that minutia.
It defines with clarity when your 120-day suspension shall begin and run.
Sorry, I didn't hear that.
Oh, no, I'm sorry. It defines with clarity when your 120 days actually runs.
I certainly appreciate what you're trying to accomplish. I understand that there is no reverse appealer actually in the strike law, so you might want to offer an amendment.
I would at this time offer, if that's appropriate, a reverse repealer in the strike off.
I think that would be great. We heard the amendment. All in favor of the reverse repealer, say aye. Aye. Any opposed, nay. The ayes have it, Senator Hill.
I think I understand what Senator Sparks is trying to do, but my concern is, no matter what date that judge orders and says that license is suspended, that person can still drive and they get stopped
DPS folks get all that entered into their system. Is that what?
That's correct, and they're in limbo, and no one is changing the amount of time suspension. You suspended 120 days, and with all due respect to the agency, and we had our commissioner here a few minutes ago, and he's done, okay, well, he's done miraculous work with driver's license, so I am not throwing a stone at DPS. But our judges, whether they're municipal or justice court judges, are judges. And when a judge signs an order, that order should be respected. So if we say to our judges, okay, put a date certain in your order that the suspension shall begin, when that gets to DPS, it should be treated as a court order. I can't ignore court orders. I can't ignore dates in court orders. So all we're asking is just to give us some clarity so that we don't have people not driving for fear of being suspended who get a letter 2 months later that says your suspension will begin at some date in the future. So, but I'm glad to work with anyone on getting the language right to accomplish this goal.
I just don't see how you can, because it's not gonna be immediate. I mean, there's no way it's gonna be immediate with DPS to be able to process that, and that person, even if the judge tells them they can't drive starting on X date, if they drive and get stopped, they're still not gonna get in trouble, because there's gonna be that lag time no matter what. And what I'm saying is you're extending the time that they can drive. You can do it this way, because there's no way that DPS is gonna backdate that suspension. I don't see how they can.
If they follow a court order, they will.
But if the person picks them up before DPS gets a hold of that, that person's not gonna know that. There's no way for that officer to know that.
Well, again, as I think Senator Seaver pointed out, and the reason with the reverse repeater in it is the language of when the judge signs the order is not my chosen language. The language would be the order, the date the judge puts in the order. So I'm with you.
I'm just saying, what you're trying to do, I think, is just impossible. I mean,
Well, last year we would have said it was logistically impossible to shorten the time at DPS, but they did that. So I'm excited to give another challenge to Commissioner Tindall and his fine staff.
he's doing a great job.
It's us. I would ask Senator Hill. I understand your concerns. I should share them. And if you would talk to your former classmate and see if Mr. Tindall and you could work out the language with Senator Sparks that we could all live with.
I don't have a problem with his language. I think his language is fine. My thing is, it just takes time to do stuff. This has been really old. That's my concern, not with your language, just the fact that I think it's right. But I'm more than happy to help you try.
Perfect. Thank you.
Because many courts, they delay sentencing. So I'm not looking at them, come back 30 days for sentencing, so. Very possibly work on something like this. Suspension starts in 30 days, suspended for 20 days. I think we can work on some language changes.
Thank you, Mr. Chairman. I'm glad we're having this discussion, and this goes to I guess my point of discussion goes to what Senator Sparks was saying. It's been my observation from different cases that, the notice provided by DPS differs or leads to confusion from the court order. As an attorney, I always go back to the court order. I've noticed Davis said that. And I'm looking at line 35, it dictates the notice, but the notice, all it is you're suspended. But there's a lot of things in the court order that either have been added or have different time periods. So where I'm going with that is if there is a way we could, it's almost like we need to have an order sent to DPS and it be a part of the notice. Because you get people there, I got a notice that I was suspended, but there's something in the court, just like Senator Super said, well, you're actually not suspended or whatever. There's confusion. So I don't know if we're just discussing, but I'm willing,
good problems.
I'm willing to
Y'all work
think
together.
we need to have a court order as part of the notice. If, I don't know why. My understanding is that court orders are sent to DPS, but it's almost like the notice of 63-152 has
I just want to speak to, I think Senator Suber had a great idea that maybe you would delay it for some time, but I agree with the premise of this bill that Senator Sparks is bringing up. Like, we do need some uniformity so a person knows today I can drive today, I can't drive tomorrow. I'm not driving today. And I mean, I hear loud and clear, and I understand Senator Hill's question and what the issue is, but at some point we have to trust the system that we created. We have to trust that people will respect judges' orders. I mean, there's a lot of judges' orders out there. There's no way for us to hover over people to make sure they're following them, and that's just not how the system works. I mean, in every system, there's going to be some people who are going to go against the system, but I believe that most people, when a judge gives an order of something, they take that order for what it is on face value, whether it's negative to the system or not. And so I definitely think this is something that whatever we need to work out, we need to work out to make it happen, because it's good for the people in Mississippi who are searching to see their license or just what happened.
Great. All right. So we have added the virtual peeler. So any further discussion?
I would move title sufficient to pass, committee sub has been.
Motion, all in favor, say aye. Any opposed, nay. You guys have it. All right, we're going to skip over another one. Time issue. So a motion to rise report. We will meet again. I think we're putting this on Tuesday of next week. On deadline next week.
Roger.
Thank you, sir. All in favor, say aye.
Aye.
First start out.